Let's drop some briefs. Some HIPAA briefs, that is. That's right. Don't be too scared.
You're listening to the Help Me with HIPAA podcast, where HIPAA and humor collide to make learning fun. Your delightful hosts are Donna Grindle and David Sims. Relax. HIPAA help is on the way.
Welcome to episode 428 of the Help Me with HIPAA podcast. My name is David Sims of HIPAA for MSPs, and joining me, Donna Grindle of Carden, back in the office.
Yes. At least for today.
Yeah. So do you want to talk any about the conference or keep it all secret or what?
You know, I like to keep my secrets from you, David. That's what makes our relationship work.
Is that what it is? I'm always afraid of what you might have on me.
No, it was a great conference, Palm Hit, which there's a lot of things that they're involved in, and but it's mostly stuff about workforce development and providing services, and they're based out of the Kennedy Space Center, so we had to do the meeting at the Kennedy Space Center with all the cool stuff around. Walk through the rocket garden to the, so that was really interesting, and got to really spend some time with a lot of folks. So it was great and got a lot of information out of it, made some great contacts, and really thank Dr. Kendra Seiler, who is our buddy from 405D that is the CEO of ComHit, that got us down there, because they're doing some really cool stuff with the CHMSP that we covered last week. And her program is something you might want to ask us about if you operate in Florida.
Yeah, you definitely might want to do that. Yeah. Yeah, that's a nice facility down there. Fantastic gift shop too. You spend a lot of time just in the gift shop.
Yeah.
But and then they've got, I don't know if you had time to take the shuttle where they take you to another area and you get to see a whole bunch of other stuff. It's really cool.
We had the option to go spend the whole day, stay an extra day, spend the whole day at the Space Center. We had that option with the shuttle, the whole thing. And I was just exhausted. I'm like, I would love to do it, but I need to just sit quietly for a little bit.
You need some rocket fuel.
Yeah. I'd done too many things, had too much fun, and had to sit still for too long. It wears me out.
All right. So today we're going to be talking about HIPAA online tracking news. And yes, we have talked about this before, not in the too distant past, but as things happen, it keeps coming back around.
I know. It's just always kind of lingering there, and we keep an eye on it. But what's hard to believe is that we often lose track of. Haven't we talked about that? You know, we'll say, did we do it? We have to go search our own episodes because we don't know. We've lost track. But we knew that at some point, but this is the one that we called spitballing website tracking, because we were just like, we don't know what to do with this, but explain it. And it was in January, episode 390. Here we are recording this one for October, episode 428. We have been busy since then. Every now and then, it just is like, we don't even pay attention to that stuff, you know?
Yeah.
So
we'll talk about more of this, and the whole episode is going to be about it. So the HIPAA briefs, the HIPAA say what, all of it is going to be about this particular topic, because we want to get the point across.
Yeah. Pay attention.
That's right. And speaking of those people who do pay attention, thank you to our donors. We appreciate your support. And thanks for keeping us on the air. Super expensive to get Donna to sit down for a little bit.
I know. And David never pays the tab.
I
He
don't,
just
but
leaves me hanging.
every so often I'll send her some brown water. That's all it takes.
Oh, she's focused again.
Yeah. So do you have a shout out to anybody you want to give,
Well, yeah, we need to do a shout out to the team at Sterling Ideas, who we got to meet in person with Joanne and Charles Gardner at Sterling Ideas down in Florida when we were down there. Great folks, and looking forward to they're doing some HIPAA for MSP stuff with us and have been doing card and stuff. So thanks, guys, for everything. Really appreciate it. And you too, Jacob.
Yep. So we found out you have a huge fan in Jacob.
Yeah. And
so
it's special. And he sent me a picture of 2 glasses of bourbon. So I'm in.
Yeah. So I have to say, Jacob, if you're listening, phenomenal framing job on that. I start sending you my stuff to be framed.
I know. I was shocked at wow. So, but anyway, that's our shout out for the day.
All right.
And now let's get down to business.
Sure. Let's drop some briefs. Some HIPAA briefs, that is. That's right. Don't be too scared. So the question being dropped today is, how do the HIPAA rules apply to regulated entities using tracking technologies? So, of course, regulated entities is a fancy way of saying covered entities and business associates, right? So here's the thing, is that regulated entities, they disclose a lot of information to tracking technology vendors when they use tracking technologies that are placed typically on their website or inside of mobile apps. And we use a term sometimes called individually identifiable health information. So IIHI. IHI. But that's kind of a precursor to another term, which is generally PHI, right? So we'll just say PHI.
Hi. I'm still stuck on that. You're going to have to keep going.
But yeah. So, but when you throw in some other things, like there could be some medical record numbers or email addresses, appointment dates, IP addresses, all that kind of stuff. Next thing you know, you've mixed it all together and it's, it turns into PHI. So it's very, very easy to go over into that realm. So when you have PHI though, and you're a regulated entity and you're collecting that information on your website or your mobile app, and you don't have the permission of those patients to do whatever you want to with that information, now you're stumbling across a very big problem with that data. And so it could be a problem. And that's why we want to talk about it with regard to the tracking technologies. Just because you can do it doesn't mean you should do it. And you could get yourself into some trouble.
So HIPAA is very clear. If it's PHI and you're a regulated entity, you have to have a business associate agreement in place to pass that data on to another entity, period. And the issue that we run into from a legal perspective, and granted, let's all remember that this law was written late 90s, brought into play early aughts. So did we really understand tracking technology back then? No. This is an area that if you go by the letter of the law, which is what they're obligated to do, it's PHI that's being sent to another party and you need to be AA. But you're not going to get Meta, for the Metapixel folks, to sign a BAA. You're not going to get Google to sign one for Google Analytics. That's just not going to happen. And there comes the root issue.
Yep, that is true. So that is our HIPAA brief, which rolls right into HIPAA say what? Because, what does HIPAA have to say about this?
It doesn't. It says nothing. However, it also says that gray area that I just mentioned, you can't do that. So the only thing you can do is make sure that you're not including what would be classified as PHI in the tracking information. So here comes the problem, though. If it's a medical website, if it's any kind of health system, then technically, if they're sending your name, your address, your geographical information, any of that associated with the health system, and potentially a diagnosis or any of those things, you start building up, and it's hard to ensure that it's not going to be PHI at some point.
Yeah. And here's the other thing that people often don't realize is that if you, for example, you have a website, and whether you're doing tracking pixels or collecting information some other way, even if that person is not a patient, there is some, how would you say it, Donna? There is an indication that they either are or will be potentially a patient or needing that type of care. And therefore it automatically just kicks it right over into that same PHI place that everything else falls into. So you could, some people say, well, they're not even a patient of mine, so I don't have to worry about this. Well, no, you do still have to worry about it.
Technically, yeah, it's kind of tricky because you're saying everybody that comes to your website is not a patient. Well, that's impossible to say.
Mm-hmm.
It's very impossible to say. So it gets very complicated to track that, and a lot of people try to do it themselves, and that's not recommended, doing that yourself, because you really need to know how to understand what data is being sent and how it's being used. Now, I do know, because working with several people on this particular topic, that Google Analytics 4, the new thing that just rolled out this summer, they believe that they have gotten it taken care of where it can track without it being PHI.
Interesting.
At least that it's one of those, we'll go with, there are very smart people looking at it who do this kind of stuff, and they believe they can make that argument that everything's okay if you do X, Y, and Z with Google Analytics 4. Not for me to get into the deep dives, but I can say that I believe there's ways you could do it, but you've got to really know what you're doing. Number one. Number two, it does limit what you can do with the data.
Right.
So you need to hire somebody that really knows what they're doing. And if you've got somebody that's doing marketing for your medical practice or your MSP or your accounting firm or any of that stuff, then you need to make sure any of that, we're going to, tune your SEO, we're going to track this, and you're getting those statistics, or you could have them. You need to double check and make sure that they know and can document exactly what is transpiring in those tracking tools.
Yeah. Yeah. Cause I know a few people who own those type of agencies, and it probably would not shock you that they don't know a whole lot about what's going on here that we're talking about.
In fact, they'll tell you right away, oh, we don't have PHI.
Yeah. That's not our problem.
Yeah. Well, do you even know what PHI is?
Yeah. Most of them don't. So they stick their head in the sand often. Now, I'm sure there are those agencies that do know how to do it, but that's the thing is you've got to do your due diligence and find them.
I've had agencies that say they're HIPAA compliant, but then they can't answer any HIPAA questions. So we know what they say about HIPAA compliant. Oh, they say they're HIPAA compliant. Have you asked them anything? No.
But they got a seal on their website.
Ask the questions.
My favorite is, but they do business with a dozen other, covered entities that I know. Yeah, that means nothing either.
Yeah. We've seen that happen too. It's like along the way, you're assuming the other people have asked the questions you should be asking.
Yeah. It's, I call it the fly trap. You've seen all the flies stuck to the fly trap.
Yeah.
Some flies going by there and go, that must be a pretty nice place to land. I'll try it. All these other flies are there. It must be good.
It smells good.
Yeah. So it's the same thing. But so this is one of the areas, though, where even though there's not anything specifically in HIPAA about it, there are some guidance around it. So you can find that. We have a link to it in the show notes where you can find guidance about the HIPAA online tracking and all that. So you can go read more about it.
Yeah. So definitely want to learn more about it, because as we talk more about the next piece of it, you'll understand, if you haven't at this point understood, why we care. So,
Yep.
All right.
All right.
What's next, David?
405D tip of the week.
Hello.
Dun, 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 dun. So, as we are in Cybersecurity Awareness Month, I want to remind you that cybersecurity is a shared responsibility and should be taken as a priority 365 days a year, unless you're in leap year. But you need to put your patient's care first, not just during October, but all the time. And as always, the HHS 405D has free resources available year-round to help you out.
Yeah, and this month we're publishing some posters direct to deal with the CSAM stuff that we've discussed just recently about the messages for this month, along with some videos freely available. Go get them. They apply to anybody because it's all about security awareness.
Mm-hmm.
So freely available. What is that? Free? Did you say free, David?
I did say free.
I did too. We're going to go with that.
Yep. Go get them.
Get
No
'em.
more excuses.
The video, you can download the video, you can put it in your LMS, you can do all that stuff. So it's additional video training. It's collateral to print out and put up in your office or send out in an email. So go have fun.
Yep. And for those of you who just cannot possibly take free, then we do have other options for you that are paid if you want paid training. So I know some of you do want to pay for it. So we have that option as well.
Well, those that say you get what you pay for and I'm not going to use the free stuff, go ahead.
That's right. All right. So let's dive into the HIPAA online tracking news update with our reporter on the scene, Donna Grindle. Over to you, Donna.
All of a sudden, it's Jim Cantori. The wind's blowing. I do miss those early days when they were younger and everybody wasn't used to them blowing around and stuff. So it was fun. So yeah, we did talk about this because it came out the end of 2022, I want to say. And it specifically says in bold in that guidance that we referenced, regulated entities are not permitted to use tracking technologies in a manner that would result in impermissible disclosures of PHI to tracking technology vendors or any other violations of the HIPAA rules. Thought that piece was interesting. Just in case. We're just going to throw that out there in case there's something else that comes up.
Yeah.
So we did cover it, like I said, in the Spitballing Web Tracking, episode 390 back in January. But things have continued to happen with that. And like I said, I've continued to have a lot of conversations. We had Google Analytics 4 come out. There's a ton of discussions happening between, technical people, lawyers, marketing people across the board, trying to understand how to come to a happy medium with this. So in May, the AHA, the American Hospital Association, sent a letter to HHS and OCR basically telling them to back off on this. Amend it, back off on it. There's too much. This has been rolled out all over the place, trying to get it reined back in, trying to do this. We need you to give us some way that we can use this technology effectively, and what you've given us now ain't gonna cut it. So that came out in May, and we've been keeping an eye on it, trying to figure out what's gonna happen next. And then you saw in July, OCR and the FTC did a joint letter, and then published the example letter and an article saying that they had notified over 130 hospital health system organizations about the use of these. And it's the press release says HHS, Office for Civil Rights, and the Federal Trade Commission warn hospital systems and telehealth providers about privacy and security risks from online tracking technologies. The key word to note whenever you're dealing with regulatory entities and lawyers is the word warn. Not like Warren, like WORN. No, it's the big Warren, the WARN. So then they gave you, here is the example letter that the joint letter that gets to the heart of the tracking technologies posed to, what they cause, blah, blah, blah. So both FTC and OCR did press releases about this joint letter, and then they gave us, the letter. So you can go, we got links to all of that stuff if you want to go read it for yourself. As always, we recommend that yes, we try to be very thorough and detailed, but we want you to go look it up yourself if it really matters or applies. So they even have the FTC had an article they put out, a blog article, lurking beneath the surface.
Dum 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 dum.
I know. Hidden impacts of pixel tracking. So basically, with all the stuff that they put out in July, the two organizations, the two regulatory entities, do not address specifically, or at least I didn't see that they specifically answered the AHA request, but they basically said, yeah, no, we're not backing down.
Mm-hmm.
So we're sticking with this. But again, it gets back to their job is to enforce the law. What does the law say?
Mm-hmm.
And based on what the law says, they are interpreting that law, which is their job, to apply to this tracking technology. And I do have to tell you, do you feel comfortable with all that tracking stuff that they do?
No, I do not. Because, you don't even know what all they're grabbing. And just, there's all kind of information they can get that you're not aware of. They can track times a day that you're doing things and cross-reference that to a bunch of other stuff and figure out all kind of things. So I don't like it.
And I get, that one pop-up about the cookies and, just keep what cookies and the tracking cookies. I always try to go turn that off. Unless it's something where it is fully integrated in what I'm doing. There are a few things where I'm like, yeah, I want you to keep up with where I'm going so that you can feed stuff about that back to me, because that's what they're doing.
Yeah, but they can look at, where did you come from? Where did you go to next?
Yeah.
Just all kind of craziness.
Yeah. Everywhere, every click you made on the website, if you think we don't know, we do know. We can tell. If you think that the internet is anonymous, unless you're on the anonymous part of the internet, there ain't nothing anonymous about it. In fact, everybody knows what you're doing. Yeah. And all you people that download all the apps, there's so much tracking going on.
Wasn't there a song about that? Every click you make, I'll be watching you, or something like that?
Yeah. Didn't they do that on something? I think it was a commercial. Yeah, there's something like that. But when you do the apps, I don't remember, I think Carla said something to me about, it's weird, such and such's app. It pops up whenever I'm around one of their locations. And I said, 'cause you're letting them track you. You can tell it no. If it's popping up and telling you these things, somewhere you're being tracked and it's tying it together.
Yeah.
And it may not be them. It could be some other thing like Meta sending it to them to say, hey, by the way, these people, do this. So yeah, you got to turn it all off.
Yeah. I remember several years ago, I had a small marketing agency, and one of the things that had just come out then was the geofencing, where if somebody walked by your place of business within a certain distance, it would pop up ads on their phone.
Oh, wow.
Yep.
Yeah. So, if you see that happening, any of that happening, you're being tracked.
Mm-hmm.
Every now and then I'll see something and I'll be like, what caught that and fed it to me? where did that particular thing, because I know when I see something, I'm like, how did that get from what I was doing to here, knowing all the things that I had set between there, but it still got there?
Mm-hmm. Because few people ever read the terms of service before they install something.
Yeah, and I do. I have little tools that'll read them sometimes depending on what they are, but, I look at it and I'm like, that particular one, I never could figure out where something tracked me to connect two things together so that I came over here and it knew to show me something.
So here's your little hack you can now use with ChatGPT is you can take your terms of service.
Oh, yeah.
And on a new piece of software, you can copy the terms of service, put it in ChatGPT and say, give me a brief summary of this information. And it'll summarize it for you and break it down into, very understandable terms. And instead of you
specifically ask about what do they do with my data and privacy and that kind of stuff.
Yep.
So, yes,
so
definitely.
Use that.
I know there's people don't understand. It's free and it's not that scary.
I know. I just recently had to pay a lawyer to draft up a contract, and there's parts of the contract I had to feed into ChatGPT and like, can you explain this to me? Because it sounds to me like it's contradicting the paragraph right above it.
Yeah.
And it breaks it down and all that. But that's because, lawyers write things that lawyers have to read and understand so they can argue about it.
Yeah. It's all about what's in the contract. It's all about the words that are used.
Yep. But it's a great tool to use for that, if nothing else.
Yeah. Well, and I mean, you can tell it to be all kinds of things. Help me research this and look here, tell me whatever you need to know. And then it'll start asking you stuff.
Mm-hmm.
So, but we digress. There is great value in AI, but it is very dangerous if it's not. It's one of those things that's like a technological nuclear weapon that anybody could get a hold of. I
bet you, though, one day soon, you and I are going to do a podcast recording, and it's not going to be us. And at the end of it, we're going to say, this whole thing was AI.
I know.
Surprise.
We already did the one where we interviewed ChatGPT. We should interview some of the other AIs. But for those of you who are in the Cardin Club, we got big surprise coming soon where we're going to have our own little AI trained on the information that's available to club members. So you just ask it a question, and it's like asking me, kind of.
Yeah, it'd be Donna GPT.
DGPT. So,
or
anyway.
Do Chat DG.
Yeah. I did call it Murphy, for Murphy the hippopotamus.
Yeah, there you go.
Yeah, it's Murphy Bot.
Murphy Bot.
But, we're doing some cool stuff with that. Really excited about what we're bringing out because there is great value in that. But take the discussion about AI and how you can put things in there. Imagine taking all of this data that they're gathering and putting it in there and saying, okay, find me people that this age group and this geography, and they could pull it out of that data.
Mm-hmm.
So if you think it's not being used for that, you need to. That's some wrong thinking. We'll just leave it at that.
Yeah, there's a massive, massive amount of data collection happening. It has been for a long time, but now they're not even trying to hide it anymore.
Well, there's a movie, a Will Smith movie, Enemy of the State, and it was done decades ago. And it was terrifying how much they were tracking him at that time. He wouldn't even be able to do today what he was able to do then to get away from them. So if you haven't seen Enemy of the State, it freaked people out back then, but they forgot about how freaked out they were, and now it's even worse.
Yep.
So go check it out.
Now you've probably seen Minority Report, right?
Mm-hmm.
So they had the pre-crimes division. They would lock people up because the precognition of the fact that you will commit a crime, even though you've not committed a crime.
Yeah. You're not going to do it, but you haven't done it yet, but we know you're going to do it.
Yeah, and so we'll lock you up. But I read somewhere last week that that's one of the things that they're talking about is that law enforcement agencies can't use AI to predetermine crimes or predetermine an individual is going to commit a crime. And I'm like, holy cow.
Well, we don't want them doing it.
It's crazy.
Yeah. And it can be horribly abused. And it's like the story of the attorney that used it to shortcut things and had it write his motion, and submitted it to the court. But the ChatGPT added fake cases to it, but it tells you you need to go look this up, and people don't get that. But the thing that we're trying to get you to understand is it's super, super powerful, and the more data they have, the more it can do, which is why this tracking stuff is so important. But the flip side of it is the value for customer service and the value for understanding your marketing, your consumer trends, all of that kind of stuff. And can I make sure that I know what somebody's looking at on my website? I had no idea so many people were interested in this one little service that we haven't invested much in. You know, it's little things like that's why you want it. And it's been used all this time without anybody saying, oh, there's PHI in there.
Yeah.
And so that's why after they sent their thing saying, yeah, we're not backing down, this past week, the end of September, the AHA was responding to a Senate RFI on health data privacy. So nothing to do with OCR directly, but used it as a unique opportunity. So the RFI said, as we examine steps to leverage technology to improve patient care while safeguarding privacy of data, we request feedback on the questions below. And that's how those RFIs work. You know, they ask all these questions, you give it answers. Well, it didn't say much about anything, but in their response to the RFI, they asked Congress to act on two specific things. The first one had to do with the tracking rule. And they put a lot of bold stuff in that one, David.
That's like screaming.
Yeah, like we really, really need you to read this part. So it is, well, they basically were saying, they talked about the tracking technology rule that's put out and been reiterated by both the FTC and OCR, which they're kind of ignoring the FTC in this. And I'm like, if the OCR says fine, but the FTC doesn't, you're still in the same. So, but that's for lawyers, not me. You know, and these people got plenty of lawyers. It's the American Hospital Association. They got a lot of people to give them input. But they say that this rule is flawed as a matter of law and harmful as a matter of policy. Hospitals and health systems can no longer rely on a broad array of third-party technologies from Google Analytics to YouTube or other video applications to help them provide their communities with reliable healthcare information. Not only does this OCR rule violate HIPAA, they say, and it's implementing regulations, but it inflicts meaningful harm on patients and public health. Now, here's all the bold stuff. You want to do the bold stuff, David? Because you can get it that firm.
Yeah. So Congress should urge OCR to withdraw the rule immediately. Congress does not need to amend HIPAA as the statute already bars OCR's new rule. AHA urges Congress to make clear to OCR that the agency should withdraw the rule immediately. I think they just said that. Yeah. AHA recommends that Congress should consider exploring how to better require entities not covered by HIPAA to protect patient privacy, especially those third-party entities that decline to sign BAAs to ensure patient privacy.
Yeah, because that's their big point is we're using these tools and they refuse to sign a BAA for it. They're not going to do it. And so that leaves the hospitals in the lurch. So I thought, and all of that's in bold.
Yeah.
So I think they reiterated it 4 or 5 times. And their logic, you can, like I said, we have links to all this stuff, so you can go read their logic about why they believe that it violates HIPAA and, anyway, not for us to go down and dirty in the deepness there, but it's important to know if you're worried about these things, this is how serious it is. So, but then they actually responded to the other bit that was unrelated to our website tracking, but I wholeheartedly agree. The website tracking is too hairy for us. We will tell you what they're saying and what we know, but I can't form an opinion on that because of how I know what the technology is doing. I know the value of it, but I also know they're dealing with what the law says.
Yep.
But the other part I thought was really good, which is what the original RFI was about, which is we're going to close out on what they were saying there. Because their point was talking about the patchwork of state and federal privacy requirements, which does create unnecessary regulatory burdens. We have always talked about how you got to worry about the state laws too, and these state laws like CCPA, and not all of them provide carve-outs for an entity regulated by HIPAA. It may provide a carve-out for PHI, but if you have data that's not PHI, it's not carved out necessarily. So they're making the point that HIPAA requirements be the uniform nationwide standard for protecting the privacy and security of patient information because it's both effective and entrenched. Congress should enact full federal preemption for HIPAA from all the state laws. So I thought, it's a huge problem and it's something I would be happy if we got off, because I hate to go back through and go, okay, well, your state, said, I know you're doing it right over here, but because of your state, and every year we have to monitor all those state rules.
Yeah.
But their point is that the HIPAA law, as we always say, it does not preempt state law that is more stringent than the requirements that it mandates. So state law is not preempted if it is, well, the way that we usually phrase it is the way to look at it is whatever gives the patient more rights, that's the one that takes precedence. Mm-hmm. So if the state law requires additional things above and beyond HIPAA, then it takes precedence. So if you operate in several states, you've got to keep up with that. But then after they mentioned up above and they talked about, I love this part, but you just said, because they did talk about the HIPAA framework is effective and entrenched, right? But further down, for all the strengths of the existing HIPAA framework, now some stuff's coming. Its approach to preemption has proven to be problematic. And they're absolutely right. So we say that it's really good, but forcing all these folks, to satisfy a myriad of legal requirements that raise compliance cost and divert limited resources that could be used on patient care. Yeah. So I totally understand it and do not disagree with this, but the privacy experts, they're going to be upset about that idea.
Yeah, the thing I don't like about that, I'm going to pick it apart for a second. I don't like the fact that they use the term, it diverts the resources that could be used on patient care. And the reason I say that is because we've been preaching for years and other entities are starting to use this too, where they're saying, look, privacy and security is patient care. And so this kind of flies in the face of that to say, well, because of this privacy and security, we can't provide patient care. I'm like, no,
Yeah.
it's the same thing. It is patient care. It's just a different aspect of it. So I wish they would not have phrased it that way, but anyway, I'm just picking it apart on that.
Well, I totally agree. That was kind of where I don't disagree with what you're saying, but I disagree with what you're saying.
Yeah, disagree with how you said it.
Yeah,
because patient care is we've known this for a while. It's gone beyond what you think of when you think of patient care. It is now the information, privacy of that information, the security of that information and data. That's where it starts. From the time somebody either goes to your website or fills out a form or comes into your lobby, patient care has already started.
Oh, absolutely. And, the minute that data is no longer available, it impacts patient care.
Absolutely.
If you can't trust the integrity of it, it impacts patient care.
Yep.
And if it gets into the wrong hands, it impacts patient care.
Yep.
So
I don't want anybody to read that and go, oh, see, patient care is not, doesn't contribute to the compliance aspects and all. Yeah, no.
Yeah. Yeah.
We've already crossed that. We fought that battle and won, so let's not go back.
Yeah. Yeah. So, it's definitely a point that I get what they're saying, and I don't disagree with the concept, but you're right. We need to make sure, yes, you're diverting limited resources that could be applied to patient care, but privacy and security is also patient care. And this kind of implies that it's not. But I think what they're really saying is because there's so many privacy and security requirements, we're having to use more resources than we should. So we're going to go with that.
Yeah, I can go with that. But yeah, as it's written, the first thing I was like, bowing my chest out. How dare you say it's not patient care?
Patient safety, patient care is what we talk about.
That's right. Yeah. Don't make me slap you.
Oh, and we're off. All right, get down off the soapbox now, right?
That's right.
But, for the most part, I get why they're making this push. And I think it's twofold. I think that their point is make sure the third parties that aren't covered under HIPAA today are covered. If you get rid of the one thing about electronic transactions that if you're not involved in these specific electronic transactions, if you don't transmit those, HIPAA doesn't apply to you. And that allows a lot of people to not, have to fall under it. And they need to change that part of it. And I don't think it would be effective to create a whole nother rule.
Mm-hmm.
I think what we need is another definition beyond covered entity and business associate.
Right.
There needs to be, a CE, a BA, and a TP. I don't know.
Yeah. This goes back to what I tell entities that, they skirt by HIPAA because, maybe it's a med spa or whatever, they collect cash. And I always tell them, look, I would advise you to go ahead and follow HIPAA. I'm not saying to sign a BAA and all that. Don't do all that. But I am saying is you should have your privacy and security program in place that matches that. Because at some point, you're going to have HIPAA for everybody, whether it's called HIPAA or something else, it doesn't matter. But you're going to have to do these things. And so you might as well go ahead and do it now.
Yeah. You and I were talking before we started recording about this is becoming a thing. There are rules for accountants, while not written very well.
Yeah.
They have the same intent. And if we could get everybody to that base level where if everybody followed recognized security practices for the security piece and really locked down who had access to what and had serious sanctions, that's a key piece. Because if there are no consequences, there are no rules.
Yep. We tried that before.
See? Yeah. Well, I mean, we're still trying it really because there's not a lot of people getting consequences.
Yeah, that's true.
But
that's why they get the HIPAA schmippa.
Yeah. Well, that's why, I always hear a friend of mine, their kids would always say, everybody remember choices and consequences. As chaos is ensuing, you got to say that. But without the consequences, that's where the problem is. And a lot of these state laws are getting really intense. And, so I think we need that third party rule. I think we need to have a little leeway or to pressure some of these organizations that are gathering this data, which they don't want those privacy rules applied to them.
Mm-hmm.
They like to do whatever they want with the data. And so it's a layer of complication, but we're going to have to deal with it because there's so many conflicting needs. Because we don't want to just give up on privacy and security. I know a lot of people do. But that's not going to work either.
Yep. It's going to be a tough battle to fight. That's for sure.
Yes.
I'm sure we'll be talking about it again. No doubt.
Yes.
All right. So that is our show for today, folks. Thanks for listening. Be sure to follow us and share us on your favorite social media site and give us a rating and review. We appreciate those. And remember, for Donna and myself, that HIPAA is not about compliance. Guess what? It's about patient care.
You've been listening to the Help Me with HIPAA podcast, hosted by Donna Grindle and David Sims. The show created to help you with HIPAA. For more information or to ask us a question, visit our website at helpmewithhipaa.com. Neither Donna Grindle or David Sims are attorneys, and they do not offer binding legal advice concerning regulatory compliance. The information in this podcast should not be relied upon or construed as legal advice in any way. Consult your attorney for legal advice concerning compliance with HIPAA regulations.